My name is Jim McGuire. I'm here today on behalf of the appellant NICA. We have co-counsel Wilbur Bruton and also Dice Malvola and Greg Thomas from the gallery as well. Your Honor, if I could, I'd like to reserve 5 minutes of time for rebuttal.
Certainly.
And if the court is so inclined, I would like a 1 minute warning.
Pardon me?
If you could do the 1 minute warning for me as well.
Boy, you guys are taxing me today. I will certainly do my best.
I appreciate it, Your Honor. Thank you.
You're going to not, I guess I should confess I was 47 seconds late the last time. I'll try to be more precise this time.
13-second warning will help too. We'll give you some guide. But in any event, Your Honor, thank you. And we're here today, as the court certainly knows, on an issue of contract interpretation. But I want to point out something that I think is a critical background fact and make sure that we're all on the same page with respect to that. But when the parties settled the class action below, the key dispute was about whether NICA had an obligation to pay families for providing care for their own children. NICA was paying most of the families in the class for some hours each day. But when we settled the case, NICA agreed that going back for a 7-year period, from 2012 back to May of 2005, NICA would pay any hours that had been missed for those families, or if a family wasn't getting paid at all, they would get paid those hours. So the agreement fundamentally provides 7 years of relief for these families. The dispute today is about an additional 4-year period, the period from May 25th, 2001 to May 25th, 2005, and whether there are any families who get paid during that additional time period. Your Honor, we believe that the issue here is one of fairly straightforward contract interpretation. If you apply the rules for understanding contracts, it leads to one conclusion. Now, one conclusion.
Isn't this case really about 2 words? For example?
I don't believe so, Your Honor. I think it's a little bit more complicated than that, although I think that word example is important. Your Honor, we think the fundamental issue here is, the fundamental rule of contract interpretation is, if the contract is unambiguous, read the plain meaning of the words. Well, the very first sentence in paragraph 8A2, the key paragraph, says that written evidence of request must have been submitted by a class member seeking payment for services provided by the class member. Now, the plaintiffs have said the use of the term class member in that sentence doesn't really have any meaning. They don't want to focus on what the term class member means. But class member is a defined term in the contract. It's a term defined by the plaintiffs and affirmed by this court. And there's a temporal component to that definition. And nobody is a class member unless and until they have a child born with a neurological injury, they file a DOA petition, and then an administrative law judge issues a final order. And then after the administrative law judge issues that final order, they provide services to their child and are not paid for those services. So up until the time of that administrative law judge's final order and the services provided thereafter, parents of NICA children are defined as claimants. That's how the statute defines them. They're claimants. They are not admitted into the NICA system. Well, the settlement agreement, Your Honor, is meticulous in its use of the expression class members. And when it describes written evidence of request, it says that written evidence must have been submitted by a class member requesting payment for services provided by a class member. When a claimant, a parent whose child does not get admitted into the system, submits a DOA petition, they are not a class member, they are not providing services as a class member, and they're not asking to be paid as a class member. So, by the plaintiff's own theory, which is essentially, let's focus on the first sentence of paragraph 8A2, they want to do that, but they want to disregard the definition of class member. And law teaches us that we're looking for the plain meaning of the agreement, and how do you find the plain meaning? Well, you can look at dictionary definitions or common sense understanding of words. But when words are defined within the contract itself, you use those definitions. Now, on top of that, when a contract is created within a highly regulated statutory scheme, as NICA is, the assumption is the parties understand the underlying statute as well, and that those terms of the statute control to the extent they're not overwritten by the contract. Well, this settlement agreement actually adopts the terms of the NICA statute, refers to the NICA statute repeatedly. And so we were set up with a dichotomy here of parents of NICA children in the early stages, when they're filing the petition, when they're seeking admission into the program, are claimants. Once they get that ALJ final order, once they then provide some service to their child, and once they then are somehow denied payment by NICA, the trigger has gone off at that point. They are now class members. But prior to that date, they're not class members. The plaintiffs don't want you to think about that temporal issue because it essentially eviscerates their argument. But that term, class member, is used meticulously throughout this agreement. For example, the word parent is used in the agreement, but the word parent is not used when we talk about people who are submitting written evidence for class. The trial judge below, when he issued his final judgment, the parties proposed a final judgment to him where we gave some further refinement to the notion of written evidence for class. It's paragraph 13D, and there's 4 subsections of the final judgment. Again, Your Honor, if you look at those 4 paragraphs in there, each and every one of them describes documents that will qualify because they were submitted by a class member seeking payment for services provided by a class member. I think the word class member is used 8 times in those 4 paragraphs. The final judgment and the settlement agreement are meticulous and consistent in use of that term. And the term has a temporal component which it can't simply be disregarded. Beyond that, Your Honor, we then get to the question you asked, which is, what about the second sentence, the example sentence? That sentence, and I think it's worth reading, it says, examples of such written evidence request are letters, memoranda, faxes, or emails actually submitted to NICA before May 25th, 2005, that requested that NICA pay the class member for providing residential and custodial parent services to his or her child. And Your Honor, obviously, the law is clear that when you're reading and construe a contract, you have to construe the whole contract. You can't disregard this sentence. And so the question is, what is the effect of that sentence with respect to the first sentence? Well, it's consistent in its use of the term class member. But when it said, why does it give examples? Why does it say a letter is an example of the type of document that qualifies for evidence request? If the plaintiffs are right that the first sentence tells us it simply has to be a written document, has to have been created before a certain date, and it has to request residential care benefits. If they're right about that, then telling us that a letter qualifies tells us nothing, because the first sentence tells us that. And telling us that a fax qualifies tells us nothing, because the first sentence tells us that. Your Honor, we've been having this dispute for close to a year now about this issue. We briefed it several times in the trial court, we briefed it here. The plaintiffs have yet to offer any explanation for what purpose those examples serve. All they say is, of course, well, those are things that qualify. But why is it in there? What does it tell us? And Your Honor, I think what it tells us is these examples are the types of documents that we, negotiating this agreement, agree are the sort of things we're looking for that are going to qualify.
But you don't, as I understood your position, is that's the exclusive list. Is that not the case?
Absolutely not, Your Honor. That is not an exclusive list. If you take a look at our initial brief, I don't have the page site for you, but we give you an example. We say, these are the examples, these are the types of things. Here are some other things, because they are similar, that will qualify. Someone sent a text message. Someone sent a postcard asking for this. If someone sent a telegram asking for this. These are all the same types of informal communications. The concern here, of course, was that a family came to NICA and said, we're in the system now, we're providing care for a child, we think we should be paid for it. And in some instances, NICA said no. In some instances, NICA said, yes, we'll pay you, but only 10 hours, even though you think you're entitled to 60 hours. We're trying to find, you know what, if you came and you asked for this and NICA said no, let's go back and remedy. Let's go back to that date. But the DOA petitions are an entirely different thing. They're not like this list of examples. Your Honor, there's a very interesting case that we cited. It's called Aero Thrust Corporation versus Granada Insurance. And in that case, same thing, where they gave a set of examples of things that were considered professional services. And the question is whether another type of service qualified as professional service. And The service in question was inspecting cranes that are used to lift engines out of jets. Now, the list of services that qualify as professional services included inspection services. But the court said, yeah, but if you look at the whole list, the list of services identified there are lists that require college education or some special training. Operating a crane is not like that. So it says, even within that list, and even with something that appeared to be covered, that's outside of the...
Well, except if it was the intent of the parties to exclude the petitions, why didn't the agreement say it?
Well, Your Honor, I think for a few reasons. First, if we're going to exclude documents, we'd be in exactly the same problem right now, because if we said no petitions are excluded and so are 2 or 3 other...
Well, that's the problem. You can't think of another one.
Well, that's because I have to think of, well, just to give you an example.
I mean, the issue here is the petition. And if the petition was clearly not in the contemplation of the parties, because you've included examples of things that are, it would logically have followed by the drafters and the negotiators to say, oh, and by the way, this isn't one.
Your Honor, I think 2 things with respect to that. I understand that argument, and that's primarily the plaintiff's argument. But I don't believe that that is actually the law. There's a second DCA case called Carefree Villages versus Heating Properties. And that was the case related to the sale of land. And the buyer had the right to do certain inspections of the land before closing on the deal. And it said the buyer shall have the right to inspect the books and records, to do soil borings and engineering surveys, et cetera, and any other activities deemed by the buyer appropriate. Any other activities. So the buyer went in and wanted to interview some of the tenants who were renting property on the land, and this court said, no. If you want to include that in the list of examples of things you can do, you should have included it. But by not including it, it's excluded from the list. And so what the plaintiffs are saying to us here is, even though that's the second DCA law, we need to read that the other way around. And if you want to exclude something, you have to, in other words, in this contract, they would have had to have said, and you cannot interview tenants. But the contract didn't say that. The contract never mentioned tenants. And this court said, if there was some issue about tenants and you wanted to interview them, put it in as included. If it's not included, then it's excluded. And that's the situation we're in here.
Is there a difference between that case, and I know it's out of Charlotte County, and what we have here today? In that case, they're talking about a covenant or a duty that was specifically allowed for, you know, to inspect the books, inspect the records. It was clearly a covenant contracted for. Here, we're talking about the second sentence, and what it means is not a covenant. The covenant or duty is to submit a written document. This is the second sentence of the phrase and how it measures. So my question is that case actually appropriate, analogous to this one, or am I slicing too fine a line here? And by the question, I'm not saying I've reached that conclusion, by the way.
You won't be surprised to know that I think you are slicing too fine a line there. I don't think the case in any way suggests that that's the way you slice and dice this, any more than the Aerothrust case with the inspection issue. They didn't parse it out that way.
Well, they said that we will not impose a duty. I think is what the end of that paragraph said. This is not necessarily the imposition of a duty. This is more, I guess I'm concerned, more analogous to a definitional term or an explanation term rather than the imposition or non-imposition of a duty. That's why I guess I'm trying to flesh out.
I also remember the language being more in the nature of limitation as opposed to being as open-ended as the language is here.
Well, if I could address both.
I'm sorry, I didn't mean to do that to you.
With respect to whether it's imposing a duty, honestly, Your Honor, I think that's something of a semantic question, because if we're saying that no petitions qualify, then we are imposing a duty on NICA to treat them as written evidence of request. So yes, it's partly definitional, it's partly assigning a duty, but I think that's what happens in the other cases as well. You know, and one of the things that I think is absolutely critical here is, well, we believe that if you use the definition of class member that they provided, then NICA is right. If you read those examples as having some meaning and some guidance to tell the court something, then we're right. But look beyond that. Look to what the parties actually did when they resolved this case. One of the class representatives, Ms. Rodriguez, filed a DOA petition in 1993. 1 minute, thank you, Your Honor. In 1993. That DOA petition contained a request for residential caretakers. So under the plaintiff's theory today, that is precisely the type of example they're looking for. She would have been entitled to payments back to the earliest possible date of the agreement, which is May 2004. But she took payments back to August 2004. The reason? Because in August 2004, she sent a letter to NICA asking to receive it. The plaintiffs, when we were dotting the I's and crossing the T's and finalizing this agreement, did not take the position they're taking today. This, Your Honor, this was an idea created out of whole cloth after the fact for the likely reason that not that many plaintiffs actually do have written evidence requests. We have a few examples of letters and faxes and things to that effect, but most of the class members don't have them. So this was a way of saying, aha, we found something, nobody thought about it, this is going to be the thing we rely on. But we did think about it because they had a chance to use it and ask for it, and they didn't use it and didn't ask for it. And then to say that we agreed to it, even though they didn't even attempt to proffer that as an appropriate type of evidence of request, I think absolutely turns the contract on its head and changes the deal that the parties made. I'll sit down.
He's really asking.
May it please the court. Good morning, Your Honors. I'm Dave Caldavia. I'm here today with Kristen Norris and Stuart Markman, and my co-counsel. We represent the 30 class member families who are affected by this written evidence of request issue. The settlement agreement and the final judgment are plain and unambiguous. NICA is asking this court unabashedly to rewrite the settlement agreement, rewrite the final judgment, to rely on evidence that breaches the merger clause of the settlement agreement, violates the parole evidence rule. In fact, the last thing counsel said violated the parole evidence rule, violated the rule against presenting evidence of settlement negotiations, violated the merger clause. This court should reject NICA's request, should apply the plain and unambiguous language of the settlement agreement and the final judgment, and affirm the trial court's order. Let me give you a broad overview of what written evidence of request is. And we've said in the brief, we think it has three basic requirements. One, it has to be a written document. Two, it has to be created and submitted to NICA sometime before May 25th, 2005. And third, the document must request information or payment concerning custodial care benefits. That's it. Those three things. Now, let me make sure I clarify something right now. No one here contends that 30 catastrophically injured children that we represent did not need custodial care benefits before May 25th, 2005. And no one here contends that the parents of those children did not provide the custodial care that those children needed before May 25th, 2005. What we're here arguing about today is whether when they submitted their class action claim form, whether they supplemented that with the correct type of piece of paper to show that they're entitled to that care, to those benefits before May 25th, 2005. That's what this case is about. Now, board number one that I put up, and I refer to them by numbers because counsel has copies of them so that they can follow along, if I may approach, is Section 882 of the settlement agreement. The definition of written evidence of request is very simple, and it's right here in this first sentence. And I'll read the part that I think applies. Such class members must submit to NICA written evidence that the class member requested such payment from NICA before May 25th, 2005. Then in parentheses and quotes, we have written evidence of request. That is the definition. That sentence is the definition of written evidence of request. I'll get to the second sentence in a moment. But since counsel brought up that there's an issue about temporal concern, the settlement agreement has all kinds of terms and conditions about once you have this written evidence, what does it mean? What's next? What's next is how much does NICA owe you? Well, how much NICA owes you depends on the start date of your back pay claim. Well, 882 doesn't say anything about the start date. It only defines what written evidence request is. The start date is found in two different provisions of the settlement agreement. The first is in subsection 8A3 of the settlement agreement, and that is found on page 73 of the appendix. And that section says that a class member can get back pay as of the date of the written evidence request was submitted to NICA, but in no event will NICA be required to pay any class member for custodial care provided prior to May 25th, 2001. I'm going to submit those are two potential start dates right there. Then you need to go to section 10 of the settlement agreement, which is on page 75. In section 10 of the settlement agreement, which is repeated in the class notice, in section 11, it says basically that all prior stipulations, agreements, and orders between NICA and the class members are going to remain in effect despite this claims process. So I submit to you that those two provisions, 883 and section 10, provide three potential start dates for your back pay claim if you have written evidence request. The first could be the date that the written evidence was provided to NICA. The second could be the date of an order or stipulation or agreement to control custodial care. And the third is, in no event can it ever be earlier than May 25th, 2001. I have to read all these things in harmony. Now so those are two completely different concepts. And NICA wants to mash them together, commingle them to say that that's all the same thing. And it's not. Written evidence request is one thing, then the calculation of benefits is the next thing. Then you get to how many hours a day is the child need this custodial care. That's another provision. What's the hourly rate that's going to be applied? That's a completely other different set of conditions. Also another set of conditions is whether the parents are professional health care providers, because a completely different set of conditions under the settlement agreement is going to apply there. So this is the definition. This simple sentence right here, and it provides two things. You have to submit written evidence, and the second thing is that written evidence requested payment for NICA before May 25th. That's it.
Could you address your opponent's argument with respect to class member?
Absolutely.
You're getting there?
I will.
Okay.
I will.
If you're in the flow, that's fine.
Thank
I just
you,
want,
Judge.
since it's sitting there, I want to make sure we didn't miss that. Okay.
I will miss that.
Okay.
But the second sentence says, examples of such written evidence are letters, memoranda, faxes, or emails actually submitted to NICA before May 25th that requested NICA to pay the class member for providing medically necessary residential custodial care and services to his or her NICA child. Examples. It doesn't say the only examples. It doesn't say examples of such, but these types of documents are definitely excluded. It doesn't say that the documents must be dated before the final order in your administrative proceeding. It doesn't say any of that, because those are examples only, intended to clarify what this settlement agreement is about for 111 families that NICA had cheated out of their benefits over these years, to understand what this settlement is about. The definition of class member. Thank you, Judge Black, for bringing that up. No one was a class member in this case. No one was a class member until August 2008. That's when the class certification order was entered, which said, you want to be a part of this case, you're a class member, and we're defining you as follows. You have to have a child that was born from January 1st, 1989, and before June 7th, 2002. You have to have a final order that says that you get future expenses as incurred. You have to have provided custodial care to your child that wasn't compensated for. August 2008, you became a class member. If their argument's correct, then no one is ever entitled to use this claim process, because at the time they requested custodial care, none of them could possibly be a class member. Makes no sense. The word class member is used to make sure that people who are not class members, and there are many people in the NICA system who aren't class members, that they can't come and try to take advantage of this agreement and say, well, you treated these people that way, I want those same benefits. No, they can be a class member to be part of this.
So then you can be a class member and not have filed a petition.
Say that again, Judge?
You can be a class member and not have filed a petition.
No, you absolutely have to have filed a petition and gone through the DOA process. You have to,
So that being the case, then why do we bother with the examples? If everybody has a petition, and if a petition is a writing?
this is a negotiated document, Judge. It took litigation for 6 years. The agreement's 81 pages long. Some things people requested, negotiated back and forth. This is what we have. I can't go outside the four. I'm not allowed to explain.
Well, we're trying to construe what appears to be an unambiguous document, and if every class member has to have filed a petition, then there would be no reason to have examples of written evidence.
No,
So I don't understand why it's there.
Because that would automatically qualify every class member.
that's exactly right. And just because you have
You're
a
just saying
petition,
that in the negotiation process, that there's some superfluous language there? Is that your argument?
no, it's not superfluous. It's examples that are provided to help.
Does every class member ask for residential care compensation?
No, thank you.
13 didn't, if I
This,
recall.
I'm putting up board
So
number
that's why you
7.
have examples? Because not everyone asked for it in the petition? Otherwise, the
Well-
petition would qualify everyone.
It could be any number of documents, and we'll get to the final judgment explains there's even more documents that are in that set of examples. But let's talk about the petition. Just because you filed a petition with DOA, every class member has to have done that. But that doesn't mean that petition is written evidence request. This section 766.305 says that when you're going to file a petition with DOA, you have an injured child, this is what needs to be included in your petition. You don't have to request the type of benefits that you're requesting. It's a list A through F. It says nothing about the type of benefits you're requesting. In fact, we presented evidence of 17 class members' petitions that say absolutely nothing about custodial care benefits.
Did any of them then submit a written request?
Yes.
Okay.
Email or otherwise?
Absolutely. Some of them were by letters. Some of them were by emails. Some of them are emails that NICA wrote internally saying, so-and-so called us today asking for custodial care benefits. And that gets us to the final judgment. After this settlement agreement was signed and class members were notified of it and things happened that are outside of record and are parole evidence, this 13D was inserted into the form of the final judgment at NICA's request. And we didn't agree that it was needed as suggested in NICA's brief, but we agreed to it. And the reasons why are, again, outside the record and parole evidence. But what 13D of the final judgment says, a document does not constitute written evidence request unless it meets the definition of written evidence or request in the settlement agreement. That one line right there. And 1 through 4. And on item 1, which we think petitions fall under, a document, doesn't say what kind of document. The document was created and in existence before May 25th, 2005, and requested that NICA pay the class member for providing residential care custodial services or request information concerning the availability of custodial care and services provided by the class member. That could be an administrative proceeding, petition, if it satisfies those requirements. It could be any other kind of document, typically letter. Item number 4 could be a document created by or on behalf of NICA. And this demonstrates a class member before May 25th requested information from NICA about the availability of custodial care. What could that be? Could be a phone message. Someone called NICA and there's a note, so-and-so called about custodial care benefits. That could be written evidence. The third one, the document demonstrates that NICA actually paid the class member for residential care services provided by the class member before May 25th, 2005, based on a request made for it. What can that be? That could be a canceled check. It could be a 1099 form that NICA issued showing that they paid. That's not a letter. It's not a fax. Not an email. Not a memorandum. Canceled check. NICA admitted on the record at the hearings below the canceled check doesn't qualify. The fourth, the document is a timesheet or other standardized form created by NICA that describes or identifies residential custodial care services provided by the class member. What could that be? Well, it's pretty plain. Timesheet submitted to NICA, It could also be a caregiver form that the doctors filled out and submitted to NICA and said that this child needs custodial care. That's not timesheets, not an email, it's not a fax, it's not a letter, it's not a memorandum. So these are examples that go beyond the list of examples, which counsel now admits today for the first time that this is not an exclusive list. They admitted just now for the first time that this is a non-exclusive list. It's not exclusive. Why would I? Why would I say that let's include petitions here? This is the definition. This is the broadest definition that I can negotiate on behalf of my clients who want fraud. Why would I say anything else? This is a beautiful definition for me. That's what I negotiate. What's really important, what really eviscerates, we heard the word eviscerate, an argument in this appeal, is found in section 21 of the settlement agreement. It's a merger clause. They're also called integration clauses. Here's what it says. This agreement is an integrated document which constitutes the entire agreement and understanding regarding the settlement between the parties and supersedes and replaces all prior negotiations and agreements, proposed or otherwise, whether written or oral, concerning the subject matter hereof. Each party acknowledges they have read and understood this agreement and have not executed this settlement agreement and release in reliance on any collateral promise, representation, or warranty, or in reliance on any belief as to any fact not expressly recited here. The parties agreed. You're going to look in the four corners, look at the four corners of this agreement to decide what it means. And if something else was said before, we don't care. It's out. And if they want to talk about parole evidence, ask them who inserted this provision in the contract. I think that would be some interesting parole evidence there. Another thing that I want to call to your attention about this parole evidence, and we keep hearing about, including Ms. Rodriguez's settlement. Here's what NICA told the trial judge below in their motion for rehearing. Because the settlement agreement is unambiguous, they agreed. They told Judge Bambino that agreement was unambiguous. The court should have excluded any parole evidence at the hearing. They said that the petitions that we submitted as evidence of NICA's breach of the settlement agreement was parole evidence. These agreements that were created years before this case was even started, that I was trying to use that evidence to explain what the settlement agreement meant, as opposed to how NICA breached that agreement. So they said, oh, they come in and said, you shouldn't have let that evidence in, Judge Bambino, because the settlement agreement is ambiguous. And extrinsic or parole evidence is admissible only when a contract is ambiguous. That's all they're relying on. Their entire case, the cornerstone of their case, is parole evidence. Inadmissible parole evidence. Evidence they agreed would never be considered. They also want to talk a lot about Ms. Rodriguez. Ms. Rodriguez's case. Ms. Rodriguez had been, everything that he said, by the way, about Ms. Rodriguez is totally parole evidence, settlement negotiations, inadmissible under Section 9.48, violates the merger clause. But let's see what the record actually does say about the settlement with Ms. Rodriguez, because everything you need to know about that settlement is right here in Section 19B of the settlement agreement, and it's also in Section 16 of the final judgment. Ms. Rodriguez has been litigated with NICA for 6 years in this case. The record shows that before this lawsuit, she didn't get custodial care benefits. She had to take her child to her job as a waitress. And that child was with her as she worked because NICA wouldn't pay her. This lawsuit was litigated for 6 years with her. At some point during the litigation, I convinced NICA to give her 10 hours a day. And we entered into negotiations. This was a package deal. This whole settlement is all in one. I negotiated with them. We were able to get NICA up to $126,000 lump sum back pay for Ms. Rodriguez. That was a compromise amount. In full and complete settlement of her claim for past custodial care through the date of August 31st, 2012. It doesn't say starting as of a particular date. Everything through the date of August 31st, 2002, exclusive of attorney's fees and costs. Moreover, NICA is going to increase her from 10 hours a day, up to 18 hours a day, instead of 10 hours a day. And that was going to happen immediately. She's going to get $126,000. She's going to go up from 10 hours a day to 18 hours a day. And the record doesn't talk about what her financial and economic situation was. And if this court, if we're to reverse and NICA gets its way and wants to hear about parole evidence, I can present some evidence about that. I can call up all the class members, the 110 class members that were sent this settlement agreement, and ask them what their intention was when they didn't opt out, when they didn't object to it, when they didn't appeal the final judgment. They don't get to rewrite the settlement agreement. They don't get to change the final judgment. They waive their rights to it, and so has NICA. And NICA now wants to rewrite and retroactively apply brand new terms and conditions to these people.
Just so you know, you got about a minute left.
Thank you, Judge. In that minute, I would like to remind this court why NICA was created. NICA was created in 1988. 1988. And the statute says it is the intent of the legislature to provide compensation on a no-fault basis for a limited class of catastrophic injuries that result in unusually high costs for custodial care and rehabilitation. This is one of the main reasons why NICA was created. From day one, from the very first case that NICA litigated, which is the Ross case that is in your record here, NICA contended that they were not liable for custodial care and services, even though that was one of the reasons they were created. It's right in the statute. They continued, the record shows example after example of them avoiding their obligation, their statutory obligation to these families. They went to the legislature and asked the legislature to eliminate and ban that request. The legislature said no. The legislature did cap it. After that, they retroactively applied those limitations on these children to again avoid their limitation. We litigated for 6 years, got a settlement agreement where they promised to pay these people, and now NICA wants to avoid its contractual obligations. And I'm asking this court not to let them do that, to affirm, to apply the plain and unambiguous languages of the settlement agreement and the final judgment. Thank you very much.
Thank you.
Thank you, Your Honor. Just a few final points. I think the first point worth addressing is the parole evidence issue that just came up, and two things on that. First of all, Mr. Caldevilla just provided you a great deal of what he called parole evidence. I'm not sure that's the right term, but I will tell you it's record outside, it's evidence outside the record. All these things about how terrible NICA is and the terrible things it did to the families, that's not in the record. We settled the case below. They act as if they proved everything in the case below. But those facts are not in the record. They have nothing to do with the interpretation of this contract. But beyond that, this parole evidence issue, we agree the contract is unambiguous. But the law says you cannot use parole evidence to contradict or alter the terms in a contract. Now, the contract says Ms. Rodriguez gets paid $126,000 approximately in back pay. If we'd gone into the trial court and said, well, guess what, Judge? We actually had a side agreement with Mr. Caldevilla where we really were only going to pay her $45,000, not that $126,000. That would be parole evidence to contradict the contract. The court can't hear that. The court can't take that as a way of interpreting the contract. But we didn't do that. What we went in and said to the court is $126,000. We absolutely agree with that number. And let us tell you a couple of facts that are not in the contract, but they don't in any way contradict the contract. They're entirely consistent with it. And in fact, Mr. Caldevilla just acknowledged they're consistent with it. She was paid back to August of 2004, the day she sent a letter to NICA. She did not rely on her DOE petitions. The class counsel, people who know the most about this case, the class representative, the people who know the most about this case, did not say that their DOE petition qualified. And they did not say their DOE petition qualified because they understood it didn't qualify. Now, the second issue, Your Honor, is Mr. Caldevilla said, oh, the temporal issue of class membership is irrelevant. It doesn't make any difference. In fact, what he said is, hey, really no one became a class member until the class was approved by this court. But again, That's just putting a spin on the class definition. Think about this example. Child is born before 2002, admitted into the NICA plan. His parents provide service to that child. They don't get paid by NICA. Now met the definition of class member. That child dies in 2007. Mr. Caldevilla is now saying, well, out of the class. But that's not right. That's not how the class is defined. The class defines that child and his parents as being in the class. There is a temporal component to this. They entered the class at one point, and unfortunately they exited at another, just as everyone will exit with death or with people determining that they can no longer provide the benefits of the children. There's a start and an end date for class certification or for class membership for all these folks. And that term, class membership, we didn't foist that upon the plaintiffs. That's their definition. That's their definition that they got affirmed up here. That's their definition that they put into the agreement, and now they don't want that definition. And that's not fair to the parties because we all agreed on that definition and used it. A third and somewhat less significant point, Mr. Caldevilla got up here and said, for the first time today, NICA's counsel has admitted that the list of examples is not exclusive. That is patently false. If you read our initial brief, one of our first points is, the list is not exclusive. It provides guidance. We make the point in our reply brief, we say, they set up a bunch of straw men, keep knocking down these straw men, and one of their straw men is that we're insisting it's only a letter, fax, email, etc. We never said that, never took that position. And finally, I think we keep circling back to the key rhetorical question here, which is, why provide that second sentence with a list of examples? What does it do? Well, I think we could even expand that question and say, why in the final judgment give some further examples, concrete examples? You know what? If NICA has a timesheet in its records, and the timesheet doesn't literally say, pay me for my time, but a parent has sent in timesheet, of course. That's the type of thing we're talking about. NICA knew, NICA was asked for it, and perhaps NICA didn't pay for it, and we want to right that wrong. Same with the other types of documents that are listed in the judge's final order. But again, that final order gives a series of concrete and specific examples. None of them are anything like a DOE petition. None of them are documents that were submitted by someone prior to their entry into the class.
If I needed to.
And none of them, if you, I hate to use this, but we all remember one of these things is not like the other, one of these things doesn't belong. Which thing is not like the examples listed in the contract? Which thing is not like the examples that the judge put in the order? Those are things where we say, you know what? NICA got a phone call and wrote its own note in the files. Yes, let's compensate for that. That was a request. NICA got a timesheet. NICA had some other record in its file saying, yes, this person came to us and asked, let's do the right thing, let's give that person the additional time. But not DOE petitions. And DOE petitions, frankly, are, despite what Mr. Caldevilla said, there is no conceivable instance where a DOE petition could ever provide the start date for back payment, no matter when the child was born. So again, I think that tells you, why would we be looking to DOE petitions if it can never do what written evidence of request is supposed to do, which is to provide the starting date for back payment. Even a child born after 2001, it won't provide their starting date, because the starting date has to be after the ALJ file. So, thank you. You're right, I don't know my 1 minute. Appreciate your time. And Your Honor, we appreciate oral argument on this matter as well. Thank you very much.
Thank you, counsel. Thank you both. Well done. At this point, our session is concluded, and we're in recess. The reason I noticed that case in Charlotte County, that's where I sat as a circuit judge, and I wondered in 1986 if I was in the courtroom when that case took place.
I should have done my homework on that one.